it was a criminal investigation that was pursued without predication that there was a crime. Would that be unusual in a normal Department of Justice?
Well, certainly when it comes to the more complicated the case, the more sensitive the case, the more predication you should have before beginning an investigation.
And when the criminal chief of the career criminal chief of the office loses her job for being unwilling to pursue the no predication criminal investigation, that in a normal Department of Justice would be another warning sign, would it not?
It would be a red flashing light.
And if the U.S. attorney went forward themselves with no career co-signer and had zero federal prosecution experience at the time, that would be more red flags, wouldn't it?
That would be very, very serious.
Sitting federal judges have said about the Department of Justice's presentations in this Trump II administration. To be clear, these are not allegations that are made about the Department of Justice by angry or frustrated opponents. These are findings made by federal judges. The sort of punchline here is that the acting U.S. attorney who performed all these stunts is now our pardon attorney, Mr. Martin. And the purpose of this whole, because they just simply didn't like that Congress had appropriated that money, and it seemed to them, having failed to block it in civil proceedings, that setting up a fake criminal investigation to try to block it was a really smart move. Right now, but at least department lawyers in the civil litigation conceded to the court that there had been no fraud. So they just tore the legs out from under the phony prosecution. And the fact that that's not a unique thing that we're all talking about, it's just part of the new run-of-the-mill misbehavior and dirty dealings and incompetence of this operation running the Department of Justice is, well, I'll let you describe the adjective.
A word cloud. That's how this hearing opens. Every single word on it came from a sitting federal judge describing what the Department of Justice has been doing in court under the Trump administration. Not Democratic critics, not political opponents. Federal judges, including judges appointed by Trump himself, writing these words in official judicial opinions. Then comes the story of a criminal investigation that never had evidence of a crime to begin with. The career lawyers who were supposed to sign the court filing refused. Every single one. The U.S. attorney who pushed it forward had zero federal prosecution experience. The magistrate denied the petition, which almost never happens, because DOJ lawyers are trained to never put a judge in that position. Then they tried to take the rejected case and shop it to other districts. The man who did all of this is now the pardon attorney of the United States. And then the number that should stop everyone cold. 11 U.S. attorneys sanctioned for misconduct in a single year. Possibly the worst in a century. Plus, a fraud upon the court allegation in Florida, tied directly to Todd Blanche. This is the hearing where a former U.S. attorney and a former Southern District of New York prosecutor compare what a normal DOJ looks like against what's happening right now. Subscribe, because this is the institutional story that matters most and gets covered least.
My questions are going to be for Mr. Carbone. I spent 4 years as the United States Attorney in Rhode Island and 4 years as our Attorney General. As you may know, Rhode Island is one of the 3 states in the country where the Attorney General has full criminal authority. We don't have DAs. It's us, Delaware, and Alaska. And so we worked very closely with my successor as U.S. Attorney once I was elected. So I've got some experience and understanding of the traditions and protocols and standards of the department. So I say that by way of opening. I have a word cloud here of things that sitting federal judges have said about the Department of Justice's presentations in this Trump II administration. To be clear, these are not allegations that are made about the Department of Justice by angry or frustrated opponents. These are findings made by federal judges. And I think every one of those words, if it had been spoken about my office when I was U.S. Attorney, would have occasioned an office response. We would at minimum have had a meeting with the attorney and asked for an explanation. It could very well have resulted in a referral to OPR, Office of Professional Responsibility, within the Department of Justice, which, by the way, I'd need to see a proof of life from right now. And it could easily have meant like going over to the court to try to make amends and set things right, because the department's reputation with courts is its most important asset. What was the case in all your years in the so-called Sovereign District of New York with respect to that type of adverse finding about the competence and honesty of AUSAs?
The word cloud is the most visually striking moment in this hearing. And for a general audience, it's worth understanding exactly what it represents. Federal judges don't choose the words casually. When a judge writes an opinion criticizing the government's presentation in court, those words go into the permanent legal record. They can be cited in future cases. They damage the government's credibility with every judge who reads them. In normal times, a single such finding from a single judge about a single AUSA would be treated as a serious institutional event requiring investigation and response. Whitehouse is showing a collection of these findings, a word cloud because there are so many that a list would be too long. And he's making a specific point. These are not findings from judges who disagree with the administration's politics. They're findings about the competence, candor, and compliance with orders of the lawyers representing the United States government in court. The proof of lifeline about the Office of Professional Responsibility is the sharpest institutional joke in this hearing, and it carries a serious point. OPR is the internal DOJ body that investigates attorney misconduct. Whitehouse is suggesting it has gone quiet under this administration precisely when it should be most active. Mr. Carbone's answer, that a judicial finding of less than candor or failure to comply with an order would be reported to Maine Justice and carefully evaluated, establishes the baseline of what normal DOJ conduct looks like. What comes next documents how far from that baseline the current DOJ has traveled.
We talk about the Justice Department losing credibility and losing the trust of the public. And we don't talk enough about what happens when you lose the trust of the bench. We have a acting attorney general who has referred to the bench as declaring war on the activist judges. I can tell you this, in my years in running White Plains in particular, as well as downtown in Manhattan, if a judge had a problem with an assistant United States attorney, and it could be what now I would see as a very minor problem, I would immediately deal with it and speak to the assistant, figure out what happened, listen to the judge's complaints carefully. But if a judge made a finding that someone was less than candid or failed to comply with an order, that's really a big deal. And when a judge makes a finding like that, under traditional, as you know, from being a U.S. attorney, that's something that would be reported to Maine Justice, and it would be something that would be carefully evaluated. If there's a Brady violation, carefully evaluated. What I think we see now is a broad lack of trust by the bench in the representations that are made by the government. There was a time when an assistant United States attorney walked into a courtroom and said, "I represent the government," that meant something. It meant something because the judges were confident that that assistant United States attorney was going to be candid, was going to be well prepared, and was going to be doing the right thing. And I think, sadly, what that collage reflects is a sentiment from many judges that's no longer the case.
For the record, that included Trump-appointed judges saying those things about lawyers. This is not just so-called activist judges. The department almost makes it worse when they receive criticism, and instead of responding to it honorably, they turn on and attack the judges, so-called activist judges. The department almost makes it worse when they receive criticism, and instead of responding to it honorably, they turn on and attack the judges. Well, you know, the judges tend to know each other. And when a judge who every other judge knows and knows perfectly well is no activist, that's just further damage to the department's credibility.
Credibility and ability to actually do the mission of the Justice Department, to carry out justice. When you don't have credibility with the court, or you lose credibility with the court more broadly.
Say a word about the presumption of regularity. What is that phrase? What does it mean? What does it matter for the department?
Well, the presumption of regularity is something that the department has enjoyed, at least in my years in the department. The judges assume that you're acting in good faith and that nothing improper happened or untoward. In the context of getting grand jury minutes or getting access to grand jury minutes, we've seen unprecedented number of judges ordering access to the grand jury minutes. That, as you know, that's something that the laws is very, it's very, very good for the government on. You don't get access to grand jury minutes unless you can show there's a reason to go behind because there is a presumption of regularity. Well, that presumption more and more is no longer attaching.
The presumption of regularity concept is the one that general audiences need explained, because it's the foundation of why what's happening matters beyond any individual case. When a government lawyer walks into court, judges don't demand that the government prove it acted properly in building its case. They assume it did. That assumption, the presumption of regularity, is what allows the justice system to function efficiently. Without it, every government case would require exhaustive judicial review of the investigative process before reaching the merits. Carbone's point about grand jury minutes is the concrete evidence that this presumption is collapsing. Getting access to grand jury minutes requires showing a court that there is a specific reason to look behind the curtain. Courts almost never grant this because the presumption of regularity means the curtain doesn't need to be open. An unprecedented number of judges are now ordering that access, which means an unprecedented number of judges have seen enough to conclude that looking behind the curtain is necessary. That's not political judges making political decisions. That's experienced federal jurists applying a high legal standard and concluding the evidence of irregularity meets it. The activist judge attack strategy that Carbone describes, where DOJ responds to criticism by calling judges activists, is the detail that reveals the most about institutional culture. Judges know each other. They know which colleagues have decades of judicial restraint records. When a restrained judge gets called an activist for ruling against the government, every other judge who knows that person's record draws a conclusion about who is actually behaving improperly. What comes next is where Whitehouse presents a specific documented case, one that illustrates every failure point Carbone just described, in sequence, in a single investigation.
If you don't mind, one last episode that I'll walk you through. This was an episode not in the Southern District of New York, but here in the District for the District of Columbia, by a political appointee directly supervised by Todd Blanche. And it was basically a cooked-up investigation. First of all, it was a criminal investigation that was pursued without predication that there was a crime. Would that be unusual in a normal Department of Justice?
Well, certainly when it comes to the more complicated the case, the more sensitive the case, the more predication you should have before beginning an investigation.
But there should, at a minimum, be some
There should
predication.
be, even in the simplest of cases,
Yep.
there should be some predication.
And when the criminal chief of the career criminal chief of the office loses her job for being unwilling to pursue the no predication criminal investigation, that in a normal Department of Justice would be another warning sign, would it not?
It would be a red flashing light.
And if no career member of the office would be willing to sign a pleading and the U.S. attorney went forward alone with zero willingness to co-sign the pleading by any career person, another red flag?
Flashing lights.
Yeah, flashing lights. And if the U.S. attorney went forward themselves with no career co-signer and had zero federal prosecution experience at the time, that would be more red flags, wouldn't it?
That would be a very, very serious problem.
Yeah, going into the magistrate's office. The magistrate judge then denied that acting U.S. attorney's petition. That's a pretty damned rare occurrence because department lawyers bend over backwards to make sure that they don't put judges in the position of having to deny petitions by super preparing to make sure that there is no occasion for a judge to deny the warrant application.
Well said. And I just want to point out, in that scenario, kudos to those career public servants who refused to sign off on that.
And then after the magistrate denied the U.S. Attorney's solo petition, the department then tried to shop the very same case to other U.S. Attorney's offices. Was that a thing in a normal Department of Justice, to get shot down in one district and try to shop the same thing to other districts?
No, that would be extraordinary, and it would be totally improper and provide yet another reason for why the presumption of regularity is something that's in serious jeopardy.
Whitehouse is walking through this case step by step for a reason. Each individual failure would be remarkable on its own. Together, they describe something that experienced federal prosecutors say has no precedent. Start with predication. Before opening a criminal investigation, DOJ requires a factual basis, some evidence suggesting a crime may have occurred. This isn't a high bar. It's the minimum threshold that separates law enforcement from harassment. Pursuing a criminal investigation with zero predication means starting with the prosecution and then looking for a crime to justify it, which is the opposite of how the justice system is supposed to work. Then the career attorneys. The career criminal chief, a senior DOJ lawyer whose entire professional identity is built around federal prosecution, refused to pursue it and lost her job for that refusal. Not a single other career attorney in the office would sign the pleading. When every experienced career lawyer in an office refuses to put their name on a document, that is the institutional equivalent of a firearm. The U.S. attorney proceeded anyway, alone, with no federal prosecution experience, into a magistrate's court where the petition was denied, an outcome that Whitehouse and Carbone both describe as extraordinarily rare, precisely because DOJ lawyers are trained to never let it happen. And then the case was shopped to other districts. Carbone calls this extraordinary and totally improper. You can't take a case that was rejected in one district and try to find another district willing to breathe. That's not how the justice system works. What the punchline reveals about why all of this happened is the most disturbing part of this entire exchange, and it lands in the final clip.
And the last bit in this particular saga was that the client agency was the Environmental Protection Administration, and the EPA administrator was on talk shows and in the public arena accusing the subjects of the failed criminal inquiry of criminality. What were the restraints when an investigation or prosecution was going on in a normal Department of Justice about either the department or its agency client publicly disparaging the putative defendant?
Yeah, so the Justice Department has very clear rules about what can be said and not said about people under investigation, or and Mr. Carr is probably an expert in this, but you certainly can't go out and disparage someone who you're investigating. Yeah, typically you stick within the four corners of a charging document. When it comes to investigations, absent certain exceptions, you really should not be talking about a pending investigation.
Because it's wrong, because it's unfair.
Very unfair.
So the way this ended, the sort of punchline here is that the acting U.S. attorney who performed all these stunts is now our pardon attorney, Mr. Martin. And the purpose of this whole set of red flag foibles and failures was to gin up a fake criminal prosecution in order to try to seize appropriated and obligated funding that was already on its way out to recipients, because they just simply didn't like that Congress had appropriated that money, and it seemed to them, having failed to block it in civil proceedings, that setting up a fake criminal investigation to try to block it was a really smart move. And that's all still in litigation right now, but at least department lawyers in the civil litigation conceded to the court, represented to the court, that there had been no fraud, So they just tore the legs out from under the phony prosecution themselves. That's a saga that never would have taken place in any other administration. And the fact that that's not a unique thing that we're all talking about, it's just part of the new run-of-the-mill misbehavior and dirty dealings and incompetence of this thug operation running the Department of Justice is, well, I'll let you describe the adjective.
Well, I agree with everything you said. There is no excuse for misusing the criminal process or the civil process for that matter. There's, when we talk about the civil settlement, we have a judicial finding, and you want to talk about predication in an investigation. You have a finding of a collusive lawsuit. The Justice Department, and I'm not suggesting anybody's guilty of any crime here because there has been an investigation, but the Justice Department has prosecuted cases where there have been collusive lawsuits where people get defrauded. The Los Angeles Waterworks, in particular, was a case that was federally prosecuted by the Middle District of California.
Well, here are 11 districts in which U.S. attorneys have been sanctioned for misconduct just in a year. I think you probably have to go back several decades to find 11 U.S. attorneys having been sanctioned, maybe a century. And this doesn't count the one that makes it the dirty dozen, which is the fraud upon the court allegation that remains pending in Florida, specifically related and directly related to Todd Blanche's misconduct in that space. So thank you very much, Senator Booker. And thank you, Mr. Carbone, for your service and for bringing a recollection of what an honest and honorable Department of Justice looks like into this grim era.
The punchline is the detail that makes this entire saga land for a general audience. The person who did all of this is now the pardon attorney of the United States. Think about what that means. The pardon attorney is the official who processes clemency applications and makes recommendations to the president on pardons. The person who pursued a criminal investigation with no predicate, fired the career lawyer who refused to sign it, found no career attorney willing to co-sign the pleading, had the petition denied by a magistrate, and then tried to shop the rejected case to other districts. That person now decides who gets to have their convictions erased. Then the purpose of the whole operation. The target wasn't a criminal. It was congressionally appropriated money, funds that Congress had voted to spend and that were already obligated to recipients. DOJ didn't like where the money was going. They failed to block it through civil proceedings, so they tried to gin up a criminal investigation to seize it instead. And then DOJ's own lawyers in the civil litigation told the court there had been no fraud. They dismantled the predicate for the criminal investigation themselves. The left hand of DOJ was pursuing a criminal fraud case, while the right hand was telling a court the fraud didn't happen. The 11 sanctioned U.S. attorneys number is the one that reframes everything as a pattern rather than an isolated incident. One sanctioned U.S. attorney in a year is a serious event. 11, possibly the worst total in a century, suggests something systematic rather than exceptional. The Dirty Dozen reference, the fraud upon the court allegation in Florida tied directly to Blanche, brings this full circle to the confirmation hearing this series has been tracking. These aren't separate stories. They're the same story about what happens to a legal institution when the people running it treat the law as a tool of political power rather than a constraint on it. Mr. Carbone closes by describing what an honest and honorable Department of Justice looks like. The contrast with what Whitehouse just documented is the most important thing in this hearing for any American who cares about whether the law applies equally to everyone. Subscribe, because this series tracks what's happening to American institutions in real time, not just the moments that make the headlines.